I'm not going to say it out loud, but you're asking that his name be changed and that the name is reflected herein.
Yes, ma'am. Yes.
Judge, I'd pass this forward.
All right. Ms. Bryant and Ms. Bryant, you are both here asking me to change the nature of your relationship with this young man, if I understand correctly. He goes by Kaz, is that right? Okay.
But that is his legal name right now, yes, sir.
Okay. So you're going to change it to the new name, right?
Yes, his legal name will be a formal.
Rowley. Okay. Well, but basically, you've been foster parents for him, if I understand correctly, and up until today, that means that you could always surrender him physically and let someone else take over responsibility for him. But after today, it falls to the two of you, and he will be the same as if he was your biological child. Yeah, that means both of you will have an equal responsibility and duty and obligation to provide care for him and to nurture him and take care of him in any way the same as if he was your biological child. You understand that? You understand everything that I've explained to you, and you're willing to accept that responsibility. You got some other children here. Who all are these?
We have our oldest, Alvin.
Okay. Hello.
There.
So this is going to be 1, 2, 3, 4, 5. I grew up in a family of 5. I was the middle child. I'm not sure what that says about it, but
That one, the girl.
well, she's probably the smartest and brightest and most articulate of all, so
Yeah, that's right.
being the middle child. All right, well, you understand the obligations you're assuming, and you want me to grant this adoption so that you can assume that responsibility.
Yes, sir.
All right, then I find that there is a basis. You've already had the surrender of rights, so I do find it to be in the best interest of Raleigh Rowley, that this adoption be granted. So I'm happy to sign the adoption.
Thank you, Judge. Judge,
Or you want, you want the whole group, or you want, I can come down there, or they can come up here. I don't
Just
care.
our immediate, our kids and.
All right, well, y'all come on up here
you
then.
want to say hi to the judge?
Yeah. Hi.
Hello. We're going up here to get a picture made.
Oh, that's
Yeah. Good boy.
That's cool. Oh, no. They won't be able to see you.
You're the middle child, right?
Yeah, that's her.
You give me a fist bump for the middle children.
Right? No, 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 no. Well, come back here, buddy. Just up there. Say cheese. Look. Thank you.
Yeah? Did you get all you wanted?
Yes, sir.
If you want a group picture, here you go. Have a middle child. You have your own individual. There you go. You're welcome. Oh, sorry. Let me put that one up. Here you go. 5 for 5. Just don't hit each other. If you want a group photo of everyone in front, you can do that as well if you'd like. So. You want the file? Well, who am I giving the file to? Oh, Hillary?
I believe so, Your Honor.
He said that end of August date would work. What was that? The 26th, August the 26th and the 28th is what was provided?
It's good for me, Your Honor. Either one.
Let's set it the 26th, if that's okay, Judge, August the 26th. Mr. Patrick said he was available. Sure.
We could begin at 3 a.m. No?
Not going in there.
That one's fun.
Thank you, Judge.
Patrick. Muted.
Judge, he gave that to me as one of his available dates.
I did. Okay, I think that's got it.
Morning, Judge. I filed this motion for scheduling order on behalf of the plaintiffs. I've sent this motion to opposing counsel on May 8th, and I've not heard a response, so I'm assuming that they have no opposition to a scheduling order being entered in accordance with the deadlines that I placed in my motion, so I would ask permission to just submit an order. It was. Thank you, Judge. I'll submit an order. Thank you.
Heather Tackett of the Robertson County Bar. I'm here today on an exception to a claim that was filed in this estate, and I have an order because I have not heard from U.S. Bank National Association. I don't believe an answer or response was filed. Thank you, Your Honor. May I be excused? That's the only thing I have before the court.
Our motion to approve final distribution, we do have some proof in that. I don't know if the court wants to do that at this point or wait.
A motion to approve the final distribution. Is there any opposition to this motion? No opposition, then your motion to approve the distribution will be granted. The first amended motion. All right, submit your order.
Thank you, Your Honor.
We have two motions this morning. We have a motion for a payment of funds for a counselor that both Briella and Davian have begun seeing. Ms. Smith advanced the payment for an annual contract for these two children to the therapist, and she is seeking reimbursement for the payment. We've attached the contract to our motion.
Ms. Smith, you'll raise your right hand. Let's place you under oath.
I do. And Ms. Smith, as guardian in this matter, a couple months ago, correct? Since the entry of the property management plan, children began seeing what's her name? Very successful.
Might want to step up just a little bit to that microphone. So.
My son, he doesn't open up to anyone, and within the first 15 minutes of session, she had him.
Okay. The real issue is you believe that this therapy and this counseling that you have the children enrolled is necessary and in their best interest.
Absolutely.
And you believe that the payment arrangements that you're asking me to approve, which would be an annual payment, the only thing I have a concern about is if we pay in advance for an entire year and then something happens and you don't pursue it, but you believe that this is in the best interest of your child and children. All right, then I will approve your request for payment arrangements.
And we also had a motion to approve attorney's fees associated with
All right. Any opposition to that?
Okay. Nothing further, Your Honor. I do have two orders on that.
I have Alana Huey, who is in the waiting room, and I've just admitted her to the hearing. There are a number of motions that are on the docket for today. Are all of these going to be for hearing?
Well, I think they're going to be very quick motions. A lot of them are discovery. A lot of them are just basically kind of, there's, Ms. Huey is pro se, and there's some issues that we need to talk about. Things like compelling mediation. But they're going to be very short. And then there's one that potentially would be long, but it's mother's motion for temporary parenting plan supplement. This is one where there's been no mediation. There's no even allegations of any type of likelihood of substantial harm. So I would argue that any type of motion for temporary parenting plan is premature at this point until we either have finish discovery, which I'm arguing, and have mediation, and we set it for a hearing. But Your Honor, I think most of these motions will just take a couple minutes.
All right, well, let's start down through them. Ms. Huey, can you hear everything okay?
Yes, sir.
Let me explain to you that under the law, once there is a permanent parenting plan that's been issued by a court and adopted by the court, that parenting plan is to remain in full force and effect. And if there's a later petition to modify that parenting plan, the court does not have the authority under the statute to modify or to adopt a different parenting plan unless there is a showing of immediate and substantial harm, a potential harm to the children. And normally that would require a detailed hearing with evidence to be supported. And if we're going to have a hearing on the adoption of a parenting plan, Ms. Huey will need to plan to be present in court rather than through the Zoom link. So let's go through
Sure, Judge,
what we
thank you.
have and let me see if I can do it.
I have a motion objecting to the mother's superseding discovery responses. On January the 12th, the mother served interrogatories and requests for admissions on, when we submitted those on February 9th, approximately not even 12 hours later.
When did you file? There are a lot of these things that I need to find a.
Oh, I'm sorry, it's our motion, this is the motion objecting to mother's superseding objection.
Right. What day did you file it?
Oh, what day did I filed it, no, I don't have the date I filed, I have the date that I signed it, but I don't
Well, I
have.
got a lot of tabs to turn to, so let me see if I can find it.
Or if you just tell me what tab you're on, I can go to that one, so I can do whatever's easy. I think I filed them all the same.
All right, well, the first motion of any kind that I find filed in this file is the motion to dismiss the counter petition for civil contempt filed February the 6th of
I
2026.
can do that one. Judge, that's one where there was a initial petition, there was an answer, and then Ms. Huey decided to just do an amended one without asking for permission from the court to do that. I understand she's pro se, but that's the reason why we asked for that.
Ms. Huey, the law, you're unfortunately held to the same standard as if you had a lawyer representing you, and under the rules of civil procedure, once a petition is filed and a responsive pleading, an answer has been filed, then you cannot amend the original petition without leave of court. You would have to file a motion asking for the court to allow you to amend your petition and then have that heard before you can actually file that. So I have to grant the motion to dismiss the counter petition for civil contempt, and then, but you're free to file a motion to amend, and, and normally that would be granted. So it seems rather circuitous and unnecessary to do it this way, but that is what the rules require.
Your Honor, may I have permission to respectfully request leave to amend here in the hearing?
You can respectfully request what?
Permission to amend that petition here in the hearing, or would you need
You have
that?
to file a written motion to amend under the rules.
Yes, sir.
So if she files that and serves that on me, that might be something we can just agree to.
If you file your motion to amend and set forth the reasons why you want to amend it, then serve that on opposing counsel, and I think at that point you would be entitled to have it heard if he doesn't agree, but I would think he would likely agree. So. All right. Then we have the motion to dismiss the counter petition for civil contempt that Ms. Huey has filed. That was filed February the 6th. That was actually the one we were talking about. And Ms. Huey, you have filed a motion to dismiss the counter petition for civil contempt.
Yes, sir.
What is your basis for that motion?
Because I gave notice to regarding the move, and there was no written objection, there was no verbal objection, and I followed the rule of the parenting plan as I understood it.
Mr. Belcher, you have anything to respond?
No. Well, let me say this, as far as I don't have
You
that.
might want to turn that microphone towards you because
Can you hear
she's
me
not-
okay?
Well,
Okay.
I'm
She
worried more
can't.
about
Okay.
her than me.
I'm talk really loud, so I usually have to, but just to make sure that she gets it. As far as that goes, I would argue that that is a case, that is a material thing that should be set at the hearing for we have a number of hearings that we maybe do, but that's not for today. I mean, that's for, that'll be an evidentiary hearing to determine that.
Ms. Huey, the civil contempt petition that's been filed is a factual issue and it's also a legal issue. And for that reason, just to say that you want to dismiss it because you felt like you complied with it, that's an allegation of fact which will have to be proven at a hearing. So while at that hearing, I'm going to pass your motion to dismiss, and we'll just reserve that for the hearing on the motion for contempt to allow both sides to be fully heard on that. All right, the next is a motion objection to interrogatories and requests for admissions that was filed March the 9th. I show it was supposedly set from April the 8th. Did you appear on April the 8th and have a hearing?
No, we moved it, Judge. We moved it to today. We've not heard any of these. Is that our motion objecting to the mother's superseding discovery responses?
The one you filed March the 9th, 2026. Motion objection to interrogatories and requests for admission.
Correct, Judge. That's the one where the mother filed 3 separate petitions in this case: to modify parenting plan, modified child support, and conversion of funds. We answered the interrogatories and requested for admissions, and then 7 hours later, she sent us 25 more interrogatories, 16 more requests for production of documents, and 87 additional requests for admissions. So what I would ask, Judge, she did that once. I guess maybe she didn't like the responses, so she decided to take a second bite of that. And I would argue that that is not proper.
There is a rule, both a local rule and a rule of civil procedure that somewhat limits the amount of questions and interrogatories and requests for admissions that you can submit. I'm going to grant the objection to the subsequent or superseding set of interrogatories. But again, if you feel that there is an additional need for something that is not fully answered in the first set of interrogatories, then you can file a motion asking for the court to approve additional discovery.
Thank you.
All right. Then we're moving to the motion for a temporary parenting plan. And Ms. Huey, I've already dealt with that. I cannot adopt a new parenting plan on a temporary basis without a full hearing.
Yes, sir. And may I just clarify, my intent is not to limit or restrict the parenting time or that he's in any danger. I'm simply seeking a parenting plan that is reflecting the reality because we've had substantial change. My older son has reached age majority. It's just dealing with our younger son and trying to reflect actual parenting arrangements and reducing conflict and communication issues was my goal.
And I understand that, and that's a, an admirable goal that you may have, but all I'm saying is that unless it's agreed to, I cannot grant or even conduct a hearing to adopt a temporary parenting plan absent showing of a substantial risk of harm or injury to the child. So we'll reserve that, and perhaps you two can come to an agreement in mediation or whatever. There's a supplemental motion to determine a child support arrearage.
Your Honor, that was the mother's motion. She's trying to seek set an arrearage from a date of divorce to present. I would argue that's also premature. We haven't done any mediation, and that would be something for a final hearing.
Ms. Huey, do you want to be heard on that? It is typical that would be a hearing that would be conducted. That would be an issue that would be heard during the final hearing.
Yes, sir. I understand that now. I was just simply seeking I didn't realize that was part of the final hearing. I was seeking to just bring matters before the court for resolution.
All right. Then we have a supplemental motion for reimbursement of child-related expenses. Again, this would be, in my opinion, a part of the final hearing as well. If there are additional expenses, child-related expenses that need to be addressed, then that normally is done at the final hearing. And it will be based on what the prior temporary parenting plan or permanent parenting plan provided. Now we're looking at motion to compel discovery responses that Mr. Huey has filed.
That's correct, Judge. We, on January 20th, we sent interrogatory responses on a number of questions, and I can submit these if you want to later, and you could do that, but there were several things that were just not answered. She objected to it, and she just didn't answer. There was, let me think, one interrogatory and production of documents. There's 1, 2, 3, maybe 6 of those, and she just to him, it wouldn't answer. And like for instance, one, I said number 20 of the interrogatory, please state with specificity all complaints and allegations on which you intend to rely on as grounds, listing specific instances of misconduct by father, and state the names and addresses of persons who witnessed or have knowledge of any instance that you have listed. And she just wouldn't answer that one, objected to that. And then do you want me to go through each one, or do you want to rule on each one of these?
I don't want to rule on them at all, but I will do what I'm required to do.
Well, fair enough, Judge. So we just want to know what she's going to say bad about the father, and we need to know what things she's going to rely on at trial, and that was the point of that interrogatory.
Ms. Huey, under the rules of civil procedure, when I first started practicing law, these rules had just been adopted. And older attorneys used to moan about the fact that it eliminated trial by ambush, which they really liked. They used to, not give the other side the information about what was going to happen, and they could ambush them at trial. The rules of civil procedure, when adopted, were designed to eliminate that, and so that both sides are entitled to have all information that's going to be introduced at the final hearing in the case. So there's no, unless there's privileged information, and that's very limited, it would be required to be divulged as to all of the information that's been requested. So do you want to have anything to say about why some of these answers were not provided?
Your Honor, I responded in good faith and provided substantial information in my responses. And to the extent that there are specific deficiencies, I do remain willing to supplement appropriate requests. However, there were several requests that raised privacy, overbreadth, and proportionality concerns.
And you want to point to me, number one, what I'm going to do is I'm going to order that you supplement your answers within a certain period of time, within 30 days that you file a supplement to your answers to discovery. And under the rules, you either answer them, or if you believe it's not appropriate, then you can file an objection to it, but you cannot just simply fail to answer it. So within the next 30 days, what I'm going to put in order down here is that you supplement your answer and you fully answer all of the questions. Any question that you believe is objectionable, then you have to file an objection stating with particularity and specificity what it is that you object to under the rules of civil procedure.
Yes, sir.
Just let me add that first one I mentioned was that. The second, I'll just kind of go over, but and I know you just said basically do all of them, but the next was that we asked for a earnings record by the Social Security Administration, that she provide that shows her past income. She didn't do that. Also, we're asking for statements of her checking, savings, money market account, and only since the date of the divorce. So it only goes back to 2020.
And why would that information be relevant?
Well, it's going to, as far as child support, that's going to be an issue, whether or not she has other income. And the same thing as far as Venmo, PayPal, Amazon, I just need to know what her income level is. That's why that would be appropriate. And as far as Social Security, I need to know whether or not she's underemployed, overemployed, whatever. But again, for child support issues, that we do that. And then I asked for a driver's license on number 16, and I asked for photographs of her home, including the outside the yard and the interior room. And the reason I'm doing that is because this is a custody case, and I want to know to make sure that there's she has appropriate place for the children to live. So those are the ones that, and let me say this too, Your Honor, when she sent her interrogatories, I sent her a deficiency letter back some time ago outlining that, but I'm going to put that in the order also that she has 30 days to answer that.
All right. Interrogatory number 9 was I'm sorry, interrogatory number 20 says, please state with specificity all complaints and allegations of which you intend to rely upon as grounds, listing specific incidents of misconduct by the father, and state the names and addresses of all persons who have witnessed and or have knowledge of any of the incidents you have listed. And then your response, Ms. Huey, was the responding party objects to this interrogatory to the extent it seeks an exhaustive catalog of all allegations, incidents, and potential witnesses, as such request is overly broad, unduly burdensome, and not proportional to the needs of the case. What you would need to understand is that he has a right to know anything that you're going to try to rely upon when you get to court. So if you intend to rely upon any type of information or incident involving Mr. Huey, you must divulge that and answer this question fully. If you do not, then when you come to court and you attempt to get into something that was not supplied to in your answer to interrogatory, then the court will be, if he objects, then the court will be forced to exclude that information. Do you understand that?
Sure.
All right. So to the extent that number 20, my ruling is that she will have 30 days to supplement that answer
Be glad to.
with those instructions.
Thank you.
There's a question number 3, provide a copy of your earnings record as provided by the Social Security Administration, and a copy may be obtained from the Social Security Administration. You have objected to that as cumulative, overly broad, and not proportional to the needs of this case, not reasonably calculated to lead to discovery. You want to answer or supplement your answer or objections on that?
Yes, sir. So my understanding is, and from what Mr. Belcher just stated, that it was from the point of divorce forward, and I have supplied my tax returns, and I'm not understanding why that is not adequate.
When was this divorce?
2024.
Okay, so you want her entire
I do,
Social
just to
Security, just
see-
let me finish
Oh,
talking.
I'm sorry, Judge, I'm sorry.
Do you want her entire Social Security Administration list of earnings back to the date she first got a job?
Well, I don't need that. I need the last 5 years. I just want to make sure that what she was making is what she is making. So basically, just to make sure that she's
When
not.
she was divorced, excuse me for interrupting you.
Yeah, no, that's okay.
When they were divorced, was there a calculation of child support?
There was.
All right, then they're bound by that calculation of child support and the showing of her income, absent some showing of fraud. So my ruling will be she's required to prove what her income is from the date of the divorce forward.
That's fine.
She says she has supplied copies of her income taxes, and that would seem to me for the years following the divorce, and that's all I'm going to require to provide.
With all due respect, Judge, the only thing I would ask is just copies of statements, checking, just to make sure that everything is listed on her taxes are also.
Well, we haven't got to that one. That one is next one, right?
Fair enough, yes.
So as to the one that says that you're requesting a copy of your earnings record, I'm not going to require you to do that, but a copy of your actual tax return form since 2024, the divorce, will need to be supplied to Mr. Belcher, and we'll go from there. The next question is copies of your statements for your checking savings in retirement accounts, which you've had an interest since June 17th. You objected to that. You provided statements but redacted transaction descriptions for deposits and withdrawals, which may be relevant. You want to be heard on that?
Yes, sir. I redacted transactions. I did not redact any withdrawals or deposits. I left all of that visible. I left all of the large transactions, for example, mortgage payments and things like that. All of that has been visible. I only redacted daily transactions that seemed overreaching, and I didn't understand why those were pertinent to the case.
Mr. Belcher?
Judge, when we look at these statements, there's a lot of things that you could find. If she goes to the liquor store 3 times a day, that might be relevant. I don't know. It might be that she's spending, if she's going on big trips. There's lots of things that potentially could be discoverable, and that's the reason why we asked for
Ms. Yancey, Ms. Huey, I'm going to order that you have to provide an unredacted copy, but it will be filed with Mr. Belcher under a protective order of this court that it's not to be used for any purpose other than for preparation for trial. And so if he obtains an unredacted copy, he is to hold that in his file under this protective order. And that's the best I can do. He is correct. We have cases that people are using their accounts for transactions to purchase liquor at liquor stores on a repeated basis right before a visitation takes place, or, you know, that there are other expenses that are inappropriate. So the transaction record can be relevant, but the best I can do is order that it be provided unredacted and that it be held by Mr. Belcher under this protective order.
And Your Honor, is that just, are we looking at, I mean, bank statements?
What he's asked for is a copy of your checking, savings, and money market or investment or retirement accounts of which you've had an interest. This is all about your income. And what he's looking to see is if there are some people who try to hide their extra income, that they make a representation that they make only, you know, this amount of money, but that their bank account records show that there's a substantial greater amount that is being deposited into the account, or that they're spending substantially greater amounts of money than their income would justify. And that's the reason that this becomes relevant.
And okay, yes, sir. So to be clear, only my bank account, my checking account, savings account, or retirement account is what we're talking about. Is that correct?
That is in number 8 of the request that says, please provide copies of your statements. If you refer to Mr. Belcher's number 8 on his interrogatories or request for production of documents, please provide copies of statements for your checking, savings, money market, investment, and/or retirement accounts of which you've had an interest since June 17th of 2024.
Yes,
So
sir.
that's the question that I'm ordering. You have to file unredacted copies, and then that will be filed with them under a protective order. The same thing goes for number 9, which is copies of Venmo, PayPal, Amazon, Zelle. I don't even know what Zelle is, Zelly, Cash App, or other such accounts that you might have. And again, it's the same principle, that they're looking for any indication that you're actually have a greater income than what you are representing. And not to say that will be the case, but they have a right to see those unredacted. So number 8 and number 9, you'll have 30 days to provide that information. It will be provided under this order, which provides that that information will be filed under seal to Mr. Belcher, and he will not be able to use or disseminate that information beyond trial preparations.
May I ask one more clarifying question?
All right.
Regarding number 9, where there's Venmo, PayPal, Zelle, things like that, are all of because a lot of those are person-to-person transactions, may I redact the names, or do the names need to be included as well?
Any reason why, if you're looking for the income information, there's really no reason the names would have to be at this point. Let me say this, we're going to allow you to redact the names. If Mr. Belcher later determines that a particular transaction is one he needs to follow up on, then he can apply to the court to have that name unsealed.
Yes, sir.
All right. Number 16, a copy of your driver's license.
And Judge, I provided a copy of my driver's license. The only thing that I redacted was my driver's license number.
Excuse me.
Number 21, provide photographs of your home, including the outside, the yard, and each interior room, including bedrooms and bathrooms. Now, you have any objection to providing those?
Your Honor, I guess I just didn't understand the reason. My ex-husband has been here several times, has been invited to come in and has declined. So I didn't understand, especially in those circumstances, how that was pertinent information and what could be gained from that.
Where your children or child is going to be residing, and where do you, and what, you don't have to tell me the address, but where are you?
Mount Juliet.
Okay. Where you are residing with your minor child does become an issue for the court to determine if the environment that you're providing is appropriate. And all I'm understanding he's asking is for you to provide copies of the photographs of the interior of your home, which normally you would do when you come into court to show that it's a good place for your son to live. So I'm going to order that you do that. It's a little bit unusual to require you to make photographs, but I can't require her to produce photographs if she doesn't have them. I can't make her go out and take photographs.
Well, let me say this in the alternative, I guess, if your court could order a time maybe for us to go out and I could take the photographs.
So you want to take them, or
I
you
don't
want
want
Mr.
to
Belcher
do
to
that,
take them?
but I'll,
I guess, honestly, Judge, it feels very invasive and intrusive,
why I asked it.
especially when the father's been invited in before and has declined to be, specifically been invited to see it, come inspect, come see where your son lives, and has declined. There are photos of the apartment complex online.
The idea that it is invasive and intrusive is correct. And unfortunately, when two people come before the court and I don't know either one of you. So I don't know anything about your house. I haven't been invited to your house. And if I or one of the other judges have to make the decision, then having the most amount of information, the greatest amount of information about the conditions, the circumstances, what it looks like. As I've said, most of the time, the person who's seeking to have the child live in that home brings photographs before the court to show this is a great environment. Here's his room. Here's what it looks like, to satisfy the judge that the child will be living in an appropriate environment. I am not going to order that she has to provide those photographs. She can either produce them or not. That's up to her. But I will say that obviously the judge who hears this case is going to want to know what kind of environment it is. And if she doesn't provide them, then Mr. Belcher, you and your client can argue to that judge or to me that her failure to provide copies of photographs that show what the environment was like may be an indication that there's an inappropriate environment.
Let me ask you, Judge, if she provides though, can she at least, I mean, if she does take pictures and she intends to show those, will she provide those to me ahead of
If you intend to
trial?
take photographs and show them at court, you have to provide a copy to Mr. Belcher. If you do not, then that's your choice, but I'm not going to require her to go out and take photographs of her own home and then mail them to you. So if she's going to take them and use them at trial, then she has to provide them to you.
Okay.
All right, that concludes the discovery issues, if I understand correctly. You've already dealt with your motion to dismiss the amended petition, which she can do. You have a motion to change venue.
Judge, the only reason I say that is the children are now, are residents of Wilson County. They've lived there for more than 6 months. The mother now is in Wilson County.
Where's your client?
My client still lives here, but I'm out of Wilson County. So it's not a big deal. Listen, it was a very pleasant drive, but it did take an hour and a half to get from Mount Juliet to here. It was very nice this morning, but that's the reason why I'm asking that. It's just for basically convenience sake for the mother, the children, me. But let me say this, if she wants to have it here, I'm
Ms.
okay.
Huey, I don't care where this case is
And I don't
heard.
either.
And if you want to have it heard in Wilson County, since you live there, then that's where the child is. That's where the court that would have the greatest opportunity to hear it. I'll be glad to change the venue to Wilson County. Do you want it changed to Wilson County?
Well, so my concern is avoiding prejudicing the matters that are already pending before the court, and particularly the unresolved financial issues, the custodial account issues that arose while that this was before the court. And my older son has now reached the age of majority. So I'm just concerned about moving it extending the times, additional costs and things like that.
And I think it would be less cost if it was done in Wilson County because everybody's there. Almost everybody's there except for the father and the father.
Normally it's the person who doesn't live in Wilson County who is objecting to it. I don't care. If you object to it being moved to Wilson County, we'll leave it here. If you want it moved to Wilson County, it should not make any difference. All that happens is that all of the pleadings that are here get transferred over under a court order to Wilson County Chancery Court.
Your Honor, I object to moving. I would like to keep it in Dickson County.
Remain here.
It'll stay here.
There's a motion to compel mediation. We have a local rule that requires mediation, so the parties will be required to undergo mediation. until, at
Judge, the
some
only
point
reason-
before the final hearing.
So the only reason I filed that is after the discovery, the first set of discovery was submitted, I had asked to set mediation up, and she refused and said that only until we provided a 408 proposal would she even consider mediation. And I don't see that as a barrier to, and I have an email that states that. But either way, Your Honor, we'll set mediation ASAP.
And lastly, there's a motion to dismiss the plaintiff's petition to modify child support. And obviously, the issue of child support is one of those things that, in my opinion, needs to be heard at the final hearing.
The only reason I put that in there, Judge, is in her petition, she was asking that it be retroactive to the date of divorce.
Well, that'll be for argument at the final hearing. You cannot get a retroactive modification of child support when there's a court order down, other than the fact that you could get it from the date of filing a petition to modify. In other words, you've got a court order down that says child support. That is controlling until you file a petition to modify. Once you file a petition to modify, if it takes 6 months or a year or 2 years to get it heard, the retroactive modification can be to the point where you filed your petition to modify. But you
Yes, sir.
can't go from the petition to modify back to the date of the actual divorce, because that's res judicata is the term we use to determine that.
Yes,
All
sir.
right.
And I amended my petition.
Mr. Belcher, would you draw an order, please,
I will.
reflecting all of my rulings, and then submit that to Ms. Huey?
I will. Judge, thank you.
All right, thank you, Ms. Huey. You may leave our hearings. Good morning.
Judge, we've got a few matters. Nicholas Bellamy, the Montgomery County Bar, Your Honor, represent Michael Thomas. We've got a few motions pending before the court this morning. We have resolved a few by agreement. We should probably start with those. The motion to compel discovery filed by Mrs. Thomas, we have agreed we will enter an agreed order requiring Mr. Thomas to complete those discovery responses within 14 days of today, Your Honor.
All right.
With respect to Mrs. Thomas's motion for contempt regarding the alimony payment, the May alimony payment or support payment, temporary support, child support payment, were paid today.
Also, the auto insurance that was cut off will be cut back on today.
That is correct.
And then there's a health insurance issue that will be reserved for the
All
final hearing.
right.
So that takes care of the motion to compel discovery and the motion for contempt. By my count, that leaves Mr. Thomas's motion to reduce support, motion to review DNA testing, and then his emergency motion for immediate return of the minor children. That kind of complicates everything. I anticipate, depending if the court's able to take up a hearing today, I do anticipate having a contested hearing on that motion.
All right, well, let me run through, I would expect that will take some time. Let me run through the remaining cases and see where we are, and I'll come back to you.
Very well. Thank you, Judge.
All right.
Taking time, I filed a motion for Mr. Bates to be arraigned and for a trial date to be set.
All right. So Mr. Himmelberg is here to represent him on the criminal contempt, is that correct?
Actually, Judge, it'll be
Mr. Yeager? You still represent him on the civil matters? All right. Then let's arraign Mr. Bates on the criminal contempt. You wish a formal reading of that allegation?
No, Judge.
Plea of not guilty will be entered. Do you want to set it for a hearing then?
Yes, Your Honor, we can, if you got Mr. Yeager's calendar, do I need to just correspond with him and give like available dates?
Well, does it necessarily have to be heard in front? I guess it should be heard in front of me. I've
Well,
given
Your
out,
Honor, the allegation is dealing with testimony that happened in front of you during the hearing.
all right, June 15th or 16th. You have the 16th.
Your Honor, I'm here on a final hearing, McNeil versus McNeil, in front of Judge Wallace
On the 16th.
on the 16th. And then on the 15th, Ms. Duke and I have a matter already set in Humphreys Juvenile, McBride versus McBride.
Okay.
Apologize, neither one of those dates.
Well, I have the 26th of May. I don't know what that looks like with.
Well, Your Honor, you have a Tyson versus Tyson competing orders, a final order in Mangrum, final hearing in Mangrum, and the hearing, I don't know what it was, King versus Oliva. That's just me. I know there's,
And then the Marlin case, you said, is that going to take most of the day? On the 29th of May?
Your Honor, I don't think it will take most of the day. That would be fine to set it if he's available on the 29th. It's a contempt and a modification of alimony, spousal support. That's the one where they tragically lost one of their children. That was just a short, that was an appearance, that was just a,
The
Mr.
29th?
Bates has reached out to me to ask to continue Marlin. I have
29th.
All right. Bates, motion for contempt.
Thank you, Your Honor.
You may. Pardon?
It was served on him, and he accepted service, and I can show you, I mean, I can email you another petition, but he accepted service on it. Yes, sir.
Thank you, Judge.
You're welcome.
Okay, then, Your Honor, the only other motion that's on the docket for today is my motion for Your Honor to consider attorney's fees. Your Honor will recall, we tried this matter over a series of 5 days, starting in August of '24 and finally ending in August of '25. And during that period of time, we were able to reach after testimony, we were able to reach an agreement on property division. And then we proceeded on the issue of adoption of a parenting plan. Both parties had requested attorney's fees. Your Honor took it under advisement after the August hearing and then issued your order in September. And what we are asking, Your Honor, is we have filed a motion requesting that the court assign attorney's fees and extraordinary fees, particularly the guardian ad litem fee. And also a mediator's fee. Your Honor will recall, I'm not going to belabor the points on doing it. I would just request that if the court considers an award of attorney's fees, that I be allowed to submit my hourly billing, and Your Honor determine which portion would be attributable. Particularly on the mediator's fee, Your Honor, you recall we went to mediation one time. We came back to court. This was when Mr. Bates was represented by Mr. Potter.
That's where he fired Mr. Potter?
In the middle of mediation, he fired Mr. Potter. We went back to try to resolve the mediation. We tried to resolve the property issues, and so we incurred an additional mediator's fee and time at that. And Mr. Bates became disheartened with Mr. Potter and because of certain issues that he fired Mr. Potter, and so that mediation should necessarily be attributable to him. Your Honor will recall that this matter originated with Mr. Bates with the criminal matter. He started out supervised visitation. We went through counselors. We came to court on, I believe, 5 different occasions for the court to expand his visitation with the children. And as a result, he pled guilty on the domestic assault. He completed a anger management. He did that. Those charges, based on the agreement with my client, were expunged from his record. And again, it's a scenario where there is an alimony award. In this case, obviously, he has a significant higher earning capacity. And Your Honor, the underlying criminal contempt matter that we've just arraigned him on, you will recall that Mr. Bates, during the pendency of this case, was supposed to deposit funds into the account. He was supposed to account for all his business dealings. And lo and behold, we find out that Mr. Bates created a secret account and paid cash for a piece of property which he purchased in his own name. He testified that he expended an exorbitant amount of funds to remodel and to build a home, to do things on that property during the pendency, all without the court permission. Those were not disclosed in discovery. That was all testified to at the hearing. And again, it's just our request, Your Honor, that Your Honor consider an award of attorney's fees on behalf of my client. I was handed today, right before Your Honor took the bench, a response that apparently was filed this morning. And again, the sum and substance of the recitation of facts is, Ms. Anderson said it's correct that attorney's fees in divorce cases are considered as spousal support and considered as an alimony award. And again, as she sets forth in her response, the factors set forth the total amount of the attorney's fees and whether the attorney's fees are reasonable, and were they necessary. Again, Your Honor, will recall we took up the better part. This case originated in 2022, and we took up virtually every time Your Honor was on the bench from 22 through 25. This case was on Your Honor's docket at each month that you were in Dickson County on these issues. And we would request that Your Honor allow me to submit my affidavit of fees and extraordinary expenses, and you consider an award.
Ms. Anderson?
Your Honor, I had filed a response. I wasn't sure if you had a copy of it.
I just looked at it in the file. I had not seen it until a moment ago.
I filed this response requesting that the motion for attorney fees be dismissed. I believe that the motion that's been filed is untimely. We had a trial where there's an order that said we were supposed to pursue attorney fees at trial. It's in an order signed by Your Honor. There was no evidence presented at the trial. Ms. Bates had the opportunity to ask for attorney fees while we were here. As Ms. Roberts had said, we were here for 5 days. I know they all weren't full days. A couple times people had gotten sick or whatever, but we were here for 5 days, and she never once brought that issue before the court. It's now been almost a year since the party's last hearing date. I would direct Your Honor's attention to the order that you signed on September 15th. We had completed about 2.5 days of trial, and we had settled the entire case with respect to alimony, property division, primary residential parent. Everything was settled. That you signed that on September 15th, 2025. And in that order, we agreed, we announced it in open court. Mr. Bates agreed that the mother, Miss Bates, was going to be the primary residential parent, and the only issue that was left was the residential schedule, like decision-making, who was going to get tax deduction, things like that. And in that order, it says that each party reserves the right to request attorney fees at that time. We knew we were coming back on July 31, 2025 for the next hearing date. And we came back on that day, July 31, 2025. There was no evidence presented. We needed a few more hours of trial time, and we came back on August 15th, and we finished up the case that morning, and there was no evidence presented during that whole entire proceeding. So I believe that this request for attorney fees now is untimely, They had the opportunity to present this during the trial, and they sat on the rights and didn't do it. You've already signed an order dated September 15th, 2025, telling the parties if they want attorney fees, bring it to your honor's attention on July 31, 2025, which they did not. It's been over a year since that was filed. And I know that, you know, it is in your discretion that you may award attorney fees. There's actually a statute on that. It's under 36-5-103. It talks about attorney fee awards, that they may be awarded, that your honor has discretion. But if you look at section C of that, it talks about a prevailing party. And a prevailing party in a contempt issue, in an enforcement issue, and if you want to alter parenting time, if you want to change custody. No, we'd already determined that the mother's going to have custody. So the issue that was left to be resolved on that last day and a half was just the father's parenting time and who gets the tax deduction and how much the child support was going to be. And the issue of the primary residential parent wasn't even on the table. So I'm just asking that this request for attorney fees be dismissed. Because Mr. Bates should have an opportunity, if you're gonna open this back up again, to look through this so that he can object to it, and he also asked for his attorney fees. And I would just point out that some of the issues that were left that last day and a half, he got what he asked for. He got a tax deduction for one of the children. He got expanded parenting time on the weekends. He got more time in the summer. The mother only wanted him to have 1 week in the summer. You gave him more time. So he had issues that were valid before the court. And I think that the issue now to bring up is completely inappropriate. On the other issue, the guardian ad litem fees, you can look back in the court's file. The guardian ad litem was appointed in March 2022. And there's just one sentence, it's paragraph 7, it's numbered 7, that Mickey Smith Esquire is appointed guardian ad litem for the party's minor children. Rule 40A wasn't followed. It should have said how much it was going to cost. It should have set her fee. It should have told them how much they were going to be putting into the clerk's office. And right before the final hearing, you're supposed to let the parties know how much this is going to be. So she did a great job, and she was in the case for 3 years. She sent us an affidavit in December, and it was, I may be making this up, it seemed like it was several $1,000s. So as soon as we got it, I had my client pay half. I said, just go ahead and pay half, and we tried negotiating, a settlement on that. But now, Ms. Bates doesn't want to pay her half. So I also believe this guardian ad litem issue has a little bit of problems, because the original order that appointed her did not talk about fees. It didn't follow the Supreme Court Rule 48, which is supposed to advise the parties what their financial burdens are going to be, but to surprise them years later with this huge bill saying you owe now this guardian thousands of dollars. It's completely unfair now and unjust for Mr. Bates to have to pay this. He did go ahead and pay half of it, and I'm just asking, if you look back at your file, the amount of assets that each of these parties were awarded, their marital estate was well over $1 million. Miss Bates got half of that. She has the ability to pay this money to the guardian ad litem, and it would be extremely unfair now, 3 years, 4 years after her appointment, to have Mr. Bates have to pay all of it. And we're asking that you just order they pay it in half, and that you dismiss the attorney fees request now at this point. Thank you.
Provisions that he asked for. He was basically asking for a 50-50 residential schedule. Your Honor's hearing, again, on the order that we entered on September 15th of 2025, it specifically reserved parties' right to request attorney's fees. There was testimony as to that she had retained me on the case and the hourly rate. Again, Your Honor took it under advisement. We did not know what was going to transpire from that. Your Honor then made in the order of September 5th, Your Honor made the specific statement on page 3 of 11. Since the parties are unable to agree, this court is required to provide a parenting plan set forth. I mean, Your Honor found they were not able to agree on anything. The stipulation at the beginning that she was the primary residential parent was done from the beginning, but argued that he should have equal time based on the court's prior evidentiary hearings and the testimony of the therapist, Ms. Pate and Ms. Morton, and the recommendation of the guardian ad litem, the court's own observation of the parties' demeanor and credibility. The court finds that an equal residential schedule would not be in the children's best interest. So we were arguing over substantive matters, Your Honor. It's to come in and say, oh, we stipulated one part of a parenting plan and therefore there was nothing to litigate. But the devil is in the details, as Your Honor knows. We litigated every aspect of that parenting plan. The final decree did. Mrs. Kelly Jo Bates is awarded an absolute divorce on the grounds of cruel and inhumane treatment, also known as inappropriate marital conduct. And again, that was the request that was made. She was victorious in getting the divorce. She was victorious in getting named as the primary residential parent and had to defend vigorously the schedule that the court finally adopted. So again, Your Honor, and as far as the attorneys, as far as the guardian ad litem fees are concerned, they were reasonable and necessary. I can provide the court a transcript if necessary about the appointment. It was my understanding at the time, and again, I didn't pull that because again, I did not, even though this motion for attorney's fees has been filed since December, I did not receive Ms. Anderson's response until right before Your Honor took the bench, and on the appointment of the guardian ad litem. It was my understanding, and again, my thing is that Mr. Potter, his attorney at the time, stipulated and agreed that that would be appropriate. And so, again, I'll have to go back and review the transcript on that. So I don't have an independent recollection. I do recall during the pendency of this that they continued to file motions to expand his residential time.
Basically, I understand Ms. Anderson, but at the time that the guardian ad litem was appointed, both parties were in agreement with it, and there was no objection made by Mr. Bates's lawyer at that time. In fact, I think both parties were more than willing to allow Ms. Smith, who has long served as a guardian ad litem in these kinds of cases before this court, and her fee schedule was known to both Mr. Potter and Ms. Roberts. So this court is of the opinion that the guardian ad litem's fees were reasonable and should be approved. However, I do find that they should be split equally between the parties, and that Ms. Bates should pay her half because that was the agreement that it was made at the time. It may not have been an agreement, but that's tacit in this court.
Yes, Your Honor. And again, I would say, Your Honor, that the evidence was clear at the court that Mr. Bates used the marital funds through the company Infinity Builders, and we produced checks at the hearing where I know at least one occasion he paid $25,000 to Mr. Potter using joint funds that my client did not have the benefit of. And then there was additional payments that were shown in the bank records that he paid Ms. Anderson through business funds. And so again, it's a scenario where the entire lifestyle of Mr. Bates was funneled through, and he was able to pay his attorney's fees as they went. And he paid Mr. Potter and Ms. Anderson through marital funds, and that was through the business that he was supposed to be putting into the account. So Mr. Bates paid his attorneys, and we,
And now here we are. Relevant statute goes back.
Well, I understand you're objecting, but let's let Ms. Roberts finish her argument, then I'll give you that opportunity.
Your Honor, it was brought up at trial. We submitted the documents, and I asked him particularly at trial. If Ms. Anderson doesn't recall that, but we did go through those documents and show
My
those at the
recollection was
hearing.
that there was an issue about Mr. Bates using the corporate or the business accounts to pay personal, including some portion of his attorney's fees. Now, Ms. Anderson, if you want to address what you were saying.
This motion was brought under Rule 54. Rule 54 has nothing to do with attorney fees. That can do discretionary costs, guardian ad litem fees. This is a totally separate issue. This is under 365101H. If you're gonna look at an attorney fee award, you have to look at the factors enumerated, so you have to look at the total fees incurred by both parties in the case, and you have to go through all these factors, you know, which party has the ability to pay them, whether they're reasonable. We have to have a trial over all of this. And I've never even seen the affidavit, so I don't even,
She hasn't submitted an
I know,
affidavit.
it
And
seems like
what-
if you would have filed it in December, you would have sent us something, but I haven't seen anything, so.
If I understood Ms. Roberts, her motion is to be allowed to file an affidavit, which she has not yet done, so.
Well, I thought her motion said just she wants to be awarded attorney fees, just like that, under Rule 54, which isn't the right rule. So, you know, I also feel like this issue has already been put in the court's order. You already spoke to this. They were supposed to bring this to the final hearing. You signed it in September saying, if you want to bring this issue of attorney fees, bring it up at the final hearing, and they did not do that. We were here all day on July 15th, and then we came back in August. They did not do that. They left the building and sat on that. And then they waited until December and said, oh, we need our attorney fees, and they filed a motion under Rule 54, never sent an affidavit for us to even look at, and here we are 5 or 6 months later for something that should have been done a year ago. And I'm just asking that if you found that it's untimely and that they didn't file it during the hearing and that it needs to be dismissed.
All right, your motion to dismiss is currently going to be overruled by the court to the extent that I'm going to allow both sides, if you choose, to submit your affidavit of attorney's fees. I will take this matter under advisement to be able, because of the multi-days that I had to deal with this case in trial, it is not, and it's been some time, it's not as fresh as what I would like to be able to rule on this. I need to review the file and my notes. So we'll take it under advisement. Both sides have 30 days to file any affidavit of attorney's fees that they wish to. I've already ruled on the guardian ad litem fee. All right.
If I could. Your Honor, we filed this motion, this petition. It's a petition to establish paternity and to adopt a parenting plan. And it is, their urgency has created itself in this matter as the parties have 2 minor children. And I believe the eldest is, will be 6 on the 22nd of this month, as well as the youngest has the same date of birth and will be 4 on the 22nd of this month. The parties were residents of Dickson County. They have had.
Both children share the same day of birthday?
They have had shared parenting of these children. The parties resided together for a number of years, a total of 7 years. They split up in a couple of 3 years ago, I think 2023. They split up and they've had an equal residential schedule since that time. During that period of time, the mother has had some significant issues with drugs and different things that have gone on. But the parties were working well together as far as sharing the children on basically a 50-50 residential schedule. Unbeknownst to my client, on the day, Mrs. Mowell, the defendant in this case, packed the children up and moved without notice, without anything. So again, it begs the question of the parental relocation statute, because again, the parental relocation statute, you can interpret it in a number of different ways. There's not been a finding of, my client never went forward and established paternity, and the parties never married. But he is listed on the birth certificate, and he was spending intervals of time with the children and basically had an equal residential schedule. And Mrs. Mowell just packed up and moved with her now paramour to Illinois with the children. And what has happened is that my client actually came in prior to the move and was thinking about filing this, and then it became an emergent situation when she packed up and moved. My client did go up and had arranged with her to visit with the children. He went up and picked up the children, and lo and behold, she got served a couple of hours after he picked up the children. And she called and threatened to have him arrested for kidnapping if he did not bring the children back immediately. So we're here ready to go forward on a temporary adoption of a parenting plan. I do not think I will have Ms. Mowell address it. I do not think paternity is at issue. His name is listed on the birth certificate. He's been held out as the parent. And so again, we would like to establish paternity today and at the very least establish a temporary residential schedule because she has absconded with the children, Your Honor.
I have a note on the docket that a Jill Carpenter,
And that was what I had received on Friday afternoon. I was not in the office. I was, as Your Honor's aware, I was in Knoxville attending my son's graduation. Late Friday afternoon, I received a email from a Jill Carpenter. I don't know Ms. Carpenter, stating that she had just been retained, and that she would be out of town this week, and would I agree to continue this? Well, given the circumstances, I was not able to communicate with her. Someone from her office called my office this morning and asked if we were going to proceed, and my assistant said that, yes, we were planning on proceeding, again, because of the extra circumstances in this matter. As an officer of the court, I will tell you that I had mistakenly set this matter on a day at the first of the month that was originally on your calendar, but you had taken that away. So we had communicated and I had directed my client to contact Mrs. Mowell to tell her not to come on that day, to move it to that day. She contacted my office and spoke with my office and wanted to make sure that he wasn't trying to pull something where she wouldn't show up. My assistant stated to her that it was our error in scheduling, and that she acknowledged, we asked for an email address where we could forward her. She refused to give us any way to communicate with her and said that she would have her attorney contact us. And that was back at the first of the month. And then I did not get notice from an attorney until, again, as I said, the email on late Friday afternoon that I didn't actually look at until later on in the weekend.
all right, Ms. Mowell, have you actually, come to the podium if you will, have you actually hired an attorney?
Yes, Your Honor.
And-
I retained them on Friday. However, we received something on the 6th. They said that her assistant or whatever, we talked to them, and she did advise me that they were not trying to pull anything on me on that date. And it was extremely rushed as well. However, our attorney did say that she is out of the office today and she will not be back until next week, and is asking for a continuance as well. And we do live in Illinois at the moment with them and their brother as well.
All right, I'm going to take a short recess. Let me see you in my office, please. Just have a seat. We'll take a recess and I'll come back.
gotten a I filed a paternity matter. Filed a paternity matter, but she was gone. I got that's what, that, I know, I gotta call her when I get back to the office. I think it will just move it. If we can't, then I'm gonna be down there right at 8. So.
Well, Ms. Roberts, you understand that this court always tends to try to make sure that where there's counsel involved, that they are given an opportunity to participate. However, I don't think that it should be continued for a very long period of time. And with her lawyer being apparently out of the office, possibly on vacation, the only thing I'm going to do is reset this for the 29th, add it to those list of cases you already have. Now, let me say this, and this is to Ms. Mowell as well as to her lawyer, and that is, obviously, both sides have the right and opportunity to parent this child. If they had an equal parenting schedule that was going on before, and I'm not saying that's what it was, that's what the argument is, then disrupting that and taking one parent completely out of the child's life is something that the court will have to consider in adopting a parenting plan. So between now and that hearing, what takes place will be evidence that the court will use in making a decision. So I'm just giving you the advice that he's the father, he needs to have contact with his child between now and the 29th, and how you two work it out is up to you. 2 children, all right. But I'm resetting it for the 29th. It will not be reset, so if her lawyer is not available on that day, she'll need to either send substitute counsel or have someone else appear for her.
Could I, and again, this is purely begging, for lack of a better way to put it, can we entice, depending on what happens, can we make sure that the children are available for residential time after that hearing?
I think they need to be here for that hearing on the 29th, so that if whatever takes place, that there will be at least an opportunity for the father to have visitation then, if not before.
Yes, Your Honor.
Ms. Roberts, draw an order which reflects the court's ruling. You need to tell your lawyer that she needs to be here or have someone here in her stead on the 29th, because we're going forward with the hearing.
Your Honor.
Thank
Your
you.
Honor, again, it's just my scenario, there wasn't a notice of hearing, wasn't a notice of appearance filed, so I wanted to ensure that, oh, you're going to come.
Well, I'm setting the hearing for the 29th, with or without a lawyer, so, all right. Apparently, there was a notice of appearance. So. Ms. Duke, are you ready on the Sartain?
Case was just filed, and I know that the courts generally will provide that time. I can look at my calendar.
Well, we're already moving quite a few things, but I don't mind the 29th, or we can do it on one of the, were you tied up on those June 15th and 16th?
15th, she is.
June. All right, let's just reset that Sartain case for the 16th. June 16th. Does that just leave us with the Thomas versus Thomas? All right, we'll go forward with your hearing on those remaining issues. We don't have WebEx, we have Zoom.
Online, Your Honor.
Rachel Thomas?
Yes, Your
Why
Honor.
is she not here? Why is she not?
We had an approved WebEx request we filed. She's in another state due to allegations of domestic violence or order of protection.
All right. Okay, that's fine. You're ready on your motion.
Good morning,
Go
Your
forward.
Honor.
Good morning.
I am. Judge, there's a few moving pieces today, and I'll do my best to kind of summarize the reasons for which we are here. There was a previous order entered by the Chancery Court on February 5th, 2026, setting some temporary support. At that time, Mr. Thomas was represented by Jacob Mathis, and Mr. Black represented Mrs. Thomas. a motion to set support, temporary support, both spousal and child support, was filed by Mrs. Thomas. And that notice was sent to counsel at the time for Mr. Thomas. At some point in between the filing of that motion and the hearing for that motion, there was a breakdown in communication between Mr. Thomas and his previous counsel. Mr. Mathis had filed a motion withdrawal that was set for that same day as the temporary support hearing. Mr. Thomas, I believe if the court were to take some testimony today, would state that he didn't have notice that the temporary support hearing were set for that day, and consequently, he did not appear at that hearing, Judge. His attorney at the time was allowed to withdraw, and then the court proceeded with setting some temporary support, and I believe the court set temporary support in the amount of $1,500 per month.
And that was a different judge than me.
It was Judge Wallace, Your Honor, I believe. And I wasn't here for that hearing either. And ultimately, so the first motion I filed is a motion to reduce or set aside the temporary support order. And that's just, I don't believe the court that day. I can't speak to what the court did or did not hear. I wasn't there. But based on my understanding, the court set that support without inquiring into my client's ability to pay. And that's all I'm asking the court. This was I believe a 17-month marriage before the parties separated. There was one child alleged, born during the marriage, presumed to be the father's. The father disputes, and we're going to get into the DNA issues here in a moment. There's one child born at the time that hearing took place, and another child that the mother was pregnant with when that hearing took place. So there's two alleged children of this marriage. The court had ordered some DNA testing to occur that hadn't occurred yet.
Let me interrupt you and just simply say, what my concern is that Judge Wallace conducted an evidentiary hearing on the February 5th, 2026 date, and following that made findings of fact that served, the findings of fact served as the basis for his making the order in the case. Now, for me to change that order would basically retry the entire temporary motion, and it seems to me that the more appropriate matter would be to reset this in front of Judge Wallace, who is here next month, and would be able to consider your motion to set aside or to modify his prior order.
And if Your Honor's inclined to do that, I'd be okay with that. I just, he didn't have, no matter what Judge Wallace did or did not hear, we know Mr. Thomas was not present, and there was no inquiry in regards to his ability to pay at that time.
Well, I'm disinclined to go behind what another judge has found and ruled upon, because there may be some other factor that, that wasn't made apparent to me. You had Judge Wallace's calendar.
Salmon depositions. Looks like I'm available June 16th.
Well, I think I'm sorry for the inconvenience, but it clearly seems to me that Judge Wallace needs to consider a motion to set aside or to amend or change the order that he did after an evidentiary hearing. So we'll reset you for June 16th.
Would Your Honor be inclined to entertain the other motions in this matter?
Well, if you're going to go in front of him on any of them, I think you need to hear him. He needs to hear them all. So.
And there is an emergency motion we filed for immediate relief that's set for today. Mother there was a child, she was pregnant at the time of the last hearing. This child's since been born without any notice to father. This child has been removed from the mother, placed in an adoptive family in Colorado.
I did read that in the file.
Father was served Friday with a petition for adoption. Father's got 35 days, according to that Colorado summons, to file documents in Colorado contesting the adoption.
Well, let me ask this question. There was an order for DNA testing. Is that because there was some question whether he was the biological father?
With respect to both children.
And if he is the biological father of this child that's now being put up for adoption, obviously he has a vested interest in objecting to that. We'll go forward on that particular issue because I think there is an emergency basis. Why has there not been the DNA testing?
And that's why we filed the motion to review DNA testing. Again, Mr. Thomas was represented by previous counsel. They had agreed, entered an agreed order to participate in the DNA testing. The order required the testing to be scheduled by the father. There was some exchange between counsel about setting up the DNA testing. Mr. Thomas notified me he was going to any lab now. There was no specific place set forth in the order to do the DNA testing. Mr. Thomas noticed me, he was going to any lab now. I subsequently noticed opposing counsel. There was no objection made to that. The DNA testing was done and paid for by Mr. Thomas there. And then shortly thereafter, mother stated that she would, I guess, not be able to do the DNA testing at any lab now, and referred us to an email that was previously sent over saying, I believe it was another DNA lab, North America, would be more convenient for her. So it just seems like every time we get close to getting DNA testing done, mother is trying to interfere with that. Now we have a child in Colorado. I don't know how we do the DNA testing with the baby in Colorado. Mother has voluntarily taken this child, or let this child be taken. I believe she relocated to West Virginia due to abuse allegations that were prior to my time. There was an agreed order I saw in the file entered between her Mr. Thomas's previous counsel, Mr. Black, allowing her to relocate. The child, I believe, was born there in West Virginia, and she subsequently has taken this child and placed the child in Colorado without any notice to the father. The first time he's heard of this child being in Colorado with these pre-adoptive parents was Friday when he received service of this petition. So we had filed the motion to review DNA testing today because we're having an extreme difficulty in getting this done. This order was entered, I believe, 2 or 3 months ago, maybe even longer ago than that, and we still don't have DNA testing done. I don't know how we accomplish it now with a child that's in Colorado.
Parties are before this court, and therefore, one option is that I simply order that the child, the mother, and the father all appear at a lab here in Tennessee, submit to the DNA samples being taken, and then we go from there.
And that's what we're asking the court for today, is enter a more clear order directing the parties regarding the DNA testing. Judge, with respect to the emergency motion for immediate return of the minor children, both of them, again, there's an issue with paternity that should have been resolved. It's not. I hope we can get that resolved very quickly. But mother has taken this child, and I would submit that the children are subject to this court's jurisdiction. I know the child wasn't born here, and opposing counsel might make some UCCJA arguments about it, but I believe this court has jurisdiction over the custody of these children. There's a pending divorce. This happened during the pendency of this divorce proceeding, and mother relocated voluntarily and is now attempting to just go behind the father's back and have this child adopted. If this is father's child, he absolutely asserts a right to custody. He wants to be the father. Mother surrendered and voluntarily terminated her parental rights. That's fine. Then the court needs to enter a 365-0 plan awarding custody to the father because he wants to be a father if he is indeed the biological father. So we're asking the court today for some immediate temporary relief, and that brings us to the other minor child in mother's care, custody, and control. We don't know. There's an order of protection that was entered and subsequently appealed by father that the court's reserved for final hearing.
And where is that? Is that in this court or is that in a different court?
It was originally in general sessions. They had a hearing, is my understanding, and then that was entered and appealed. So there's still an order not allowing Mr. Thomas to have contact, and he cannot have contact with Scarlett Thomas. I believe she's almost 2 or 3 years old now. But we're asking the court to return both of the children to father. We don't know what mother has put a child up for adoption. We don't know where Scarlett's located. We don't know how she's doing. We don't know if mother's a fit and proper parent to have sole custody of Scarlett. She has given the other child up for adoption. And so we're asking the court for a more clear order regarding the DNA testing, to order the parties to have DNA testing completed within a specific amount of time. And we're asking the court to enter an order to have baby Thomas brought back from Colorado to Tennessee, and to have Scarlett Thomas returned to the father. I think it's a threat of irreparable harm that this child's outside of not only this state, but in Colorado. Mother, by the attachment with what father was served on Friday, it is clear mother has consented to the termination of her parental rights. So we're asking the court for that emergency relief today.
Your Honor, I do have a response on both of those. Would you like me to tackle the DNA testing or the emergency?
Let's start with the DNA testing.
Your Honor, so the DNA testing, so my recollection of events and what has happened is that there was an agreed order between Ms. Thomas and Mr. Mathis. So Mr. Thomas's prior attorney, that was last year. Subsequently, Mr. Mathis withdrew. There was no contact between us. Had to hire a personal process server to actually serve Mr. Thomas some documents to try to find him. At that time, Ms. Thomas was absolutely willing to do DNA testing. And there was just nothing until very recently, there was a renewed push for the DNA testing, which Ms. Thomas is willing to do. I will point out to the court that Ms. Thomas is in another state due to domestic violence, which Mr. Thomas was convicted of in General Sessions Court by plea of guilty. She is in another state due to violations of an order of protection for multiple house break-ins, for following her to a medical facility and taking her vehicle. These are the reasons that Ms. Thomas is out of state. And so in an effort to preserve Ms. Thomas's undisclosed location, a essentially secret address, we were trying to coordinate DNA testing that could occur both locally here and where she was located. And that is why I proposed LabCorp. My understanding is when I had proposed that is the testing location we were going to use. And then I received communication that is not the testing center that was used. And then at this point, we reached an impasse.
So are you saying that LabCorp is available to do the testing both for Mr. Thomas here as well as for your client wherever she may be living?
So here as in Hendersonville, Your Honor, and where my client is living. That was our proposition. I will say that while I have nothing to give the court at this exact moment, my understanding is that the newborn child of this marriage is located in Denver, Colorado, which I found out about, to make it clear to the court, found out about Thursday evening.
Who is the father of that child?
So Ms. Thomas is going to say it's Mr. Thomas. I believe Mr. Thomas wants the DNA testing.
So we're gonna, the order went down only as to Scarlett Thomas.
That's my understanding.
And there was a DNA request as to that child, and now we have another child born, and Mrs. Thomas says that is Mr. Thomas's child.
Yes, Your Honor.
And she has placed that child for adoption?
That is my understanding. I will say on Ms. Thomas's behalf that there appears to be some evidence that this was an understood plan between them when they found out that the child was going to be born. That actually, according to Ms. Thomas and perhaps some messages she would admit at hearing, Mr. Thomas has spoken to the adoptive parents before, that there was some dispute over whether they were going to raise this child or not. And at this point, Ms. Thomas could speak for herself.
Well, if there is an afterborn child that was born while this case has been pending, then this court has jurisdiction over that child regardless of what has been filed in the state of Colorado.
Well, Your Honor, I will say simply for the fact that I do not want to waive any jurisdictional issue, and I've not had time since this was an emergency order filed. I would like to file the detailed response. I will raise a jurisdiction issue just to preserve it under the UCC JEE. It's not so clear which is the home state because the newborn child, if we parse them apart, right? The older child, absolutely concur with Your Honor. The youngest child, there may be some dispute over what is the home state. I have been informed that the state of Colorado has decided that they have jurisdiction and they are proceeding with this adoption proceeding. Again, I'm in candor to the court, it's a complicated issue to me, and I would need to file a brief and research that to give a response. But I do want to raise the objection that for the youngest child, may not be the home state. But besides those things, Judge, I would also say.
You cannot divest this court of jurisdiction.
Understood.
By sending a child that is one of the children of these parties with a pending divorce action where custody of one child is already at issue, and then send one of the children that is alleged to be the biological child of Mr. Thomas. You cannot then send that to another state, that child, and defeat the jurisdiction of this court to make a custody determination. So I just want to make that clear that this court's opinion is that this court has jurisdiction over both children if they are in fact the children that were born of these parties. And that is what I'm told by both of you today. So I'm of the opinion that Mr. Thomas needs to contest the adoption, and if he does contest it, contest that adoption, I'm going to put an order down that's going to require both of the children to undergo DNA testing. How that is accomplished is going to be up to you and your client. That means that she's going to have to ensure that that child is coming back and is tested. Now, we had a case not too long ago in this court where there was a woman who claimed to be a biological heir of an estate, and she lived in Washington State. There was a method by which she used a laboratory in the state where she lived to obtain her DNA sample. Then that was compared to DNA samples that were tested here in Tennessee. It would seem to me that's what's going to have to happen here. You're going to have to obtain a DNA sample from this child in Colorado and a DNA sample from your client and her child wherever she is living. And then a sample will be taken from Mr. Thomas here at LabCorp. And all of those are going to have to be analyzed by LabCorp to determine the paternity issue. The order that this court puts down is that this court maintains jurisdiction over the parties and both minor children who have been represented to this court by counsel to be the biological children of these parties. And that the adoptive court in Colorado, obviously this is going to be an issue for the appellate courts if it goes through as a contested matter, but I think we got to first resolve if this child in Colorado is Mr. Thomas's biological child. If it's not, then there's no issue. If there is, then he has to take the steps to contest it there in Colorado. He cannot ignore the Colorado proceeding and rely upon this court's ruling, because Colorado may say, we don't care what Tennessee does. We're holding that we have jurisdiction. I'm ruling, I don't care what Colorado says. I'm saying I have jurisdiction, so.
Understood, Your Honor. On the emergency petition, essentially to return, I guess, both children to Mr. Thomas, on Ms. Thomas's behalf, I would also say that,
No, excuse me for interrupting, I apologize. Is there an order of protection still in full force and effect?
Yes, Your Honor, there is. There's also a pending contempt for those house break-ins. That is also in effect.
And under that original order of protection, what provision is made for, I don't have the order of protection in this file that I can.
I can provide it. I believe Mr. Bellamy had said that Scarlett is listed under it, which is our oldest child. I did not see that, but I can provide it.
Well, and my question, of course, is what, if any, provision is made in that order of protection for the one child that's there that we know, Scarlett.
So I'm looking at the petition, and just looking at the petition, I do not see Scarlett listed on the petition, but it was the.
Thank you. This is the temporary order that I've been handed. And then you're saying that there's already been a hearing on that temporary order of protection and it was extended?
Yes, Your Honor.
And was that in circuit court or general sessions, and then it was appealed?
It was appealed, and the appeal was not heard, and by agreed order, it was set off.
It was reserved for final hearing by
That's
previous
correct.
counsel. So it's my understanding the order of protection that was entered by the General Sessions Court is still in effect, and Mr. Thomas has no contact with either the petitioner nor the minor children covered under the order of protection.
Well, I'm looking at the order that was entered in this court after the hearing on February the 5th. In paragraph 2 of the findings of fact is the wife testified that she had been married to Mr. Michael Thomas, husband, since 2024. The wife testified the parties have a 10-month-old daughter born of the marriage, Scarlett Thomas, and that she was also pregnant with the marriage's second child, which is due in early March. So according to Judge Wallace's finding, and that's the order that you're asking to be set aside, he made a finding based on her testimony that that was in fact the child of the marriage that's now in Colorado sought to be adopted. And it goes on to talk about these findings of fact. Nowhere in that order does it specifically order anything other than temporary spousal support. It doesn't put an order down regarding the temporary parenting plan or custody of the minor child.
That's my understanding as well, Your Honor. If I can say, though, we would object to Mr. Thomas having the children, and there's a lot of reasons to that maybe perhaps Ms. Thomas could add with testimony, but she's been the primary caretaker.
Well, Mr. Thomas filed for DNA testing. I'm not going to grant him custody of children that he has a question of whether or not.
Yes,
When
Your
I
Honor.
started practicing law, that was a factor that if a parent, a father requested DNA testing, that was a factor the court could consider among all the other factors in determining whether or not he ought to have, what type of visitation or custody or whatever. So if he's questioning whether this is his child or not, then I'm not likely to say those children have to come back and live with him, especially in view of the fact that there are orders of protection in place.
Pending any questions, Your Honor, I have nothing else to add.
This is a mess. And I'm going to do one thing. I'm going to check with Judge Wallace. It may be better if I heard this case and through its, I don't really want to, but it may be better if I can do it. We checked on your availability on the 16th, is that correct?
Yes, Your Honor, I'm available.
But what about the 15th?
I can check.
What did we set on the 16th? Anything for me? Yeah, I can give you the 16th.
16th would work for me, Your Honor.
I'd like to just check with Judge Wallace. If he doesn't have an objection to me hearing the motion that you filed, then I would suggest we hear everything on the 16th. And if Ms. Thomas, I think we need to get this DNA testing done as soon as possible.
Understood.
Judge,
So we're talking about June 16th to hear everything, all of these motions, and between now and then, I want the DNA testing performed on both Scarlett and the child that's in Colorado. That DNA testing will be performed by a sample taken by Mr. Thomas by LabCorp here in Hendersonville, a sample for Mrs. Thomas and the minor child Scarlett in the state where she resides by LabCorp, if there is one there, and by LabCorp in Colorado where this minor child is. It would be Mrs. Thomas's obligation to ensure that the child's sample is taken and that proof is obtained from Colorado of the validity of the identity of that child. In other words, I tell you this story that we had a well-known ne'er-do-well down in Humphreys County who is a member of a famous music family down there. And he was hired, or rather he was sued for child support. Back in that day, they set you up with the father and the mother, and the child all went to get the blood test done. So came back negative, and the mother just was irate, could not believe it. And anyway, they apparently took a picture of the father and the child and the mother. It wasn't the defendant. He had sent one of his buddies to go sit in his stead, and of course, it came back, it wasn't, and later it was his child, so they had to redo it. What I want is to make sure that that child is identified in the state of Colorado sufficiently by whatever means, photography or whatever, that we can ensure that Mr. Thomas knows this child that is being tested in Colorado is in fact the same child that we're having questioned. And so I think we do that DNA testing, and I'd like to have that done within the next 10 days on all parties, and then we reset it for June 16th, and hopefully we'll have the results of that at that time. And I will check with Judge Wallace to see if he has any objection to me considering your motion to modify his order, and then we'll go from there. All the other motions, I would think, need to be heard on that same day. I realize it's an emergency type situation, and that's why I'm giving you the June date. I'm supposed to be in Humphreys County that month, so.
Appreciate it, Judge.
Anything else?
If I may, Judge, and this kind of gets into the temporary support, I don't want to do that.
Well, he pays for his test, he pays for his test, she pays for her test, and he's the one who's requesting the testing, so it's gonna, understand that I'll consider that at the final, at the next hearing, but he's gonna have to bear the cost of the test itself. She will pay for the test for herself and the two children. He will pay for his test and the performance of the actual DNA testing.
So we'll go with an itemized list of what the charges are for the test, and she's
Correct.
responsible for herself.
Right.
Understood, Your Honor.
Otherwise, the other option you have is tote that child back from Colorado, bring it here, and have all three of them, have all three, your client and the two children, tested at LabCorp in the state she lives in. That's
Understood,
the
Your Honor.
simplest.
And I'm going to ask just one clarification and request to this court. If those are determined to be Mr. Thomas's children, can Ms. Thomas be reimbursed for her cost of the test?
If they are Mr. Thomas's children,
Yes, sir.
she can make application for reimbursement at that point in time.
Understood.
Normally, if someone contests that being their child, and it turns out they are, then they requested the DNA, they have to pay for it in the end result. But as was pointed out, if he's incurring a great deal of expense to fight an adoption of a child he never consented to being adopted, then that may be a factor as well. So,
Understood.
all right. I'm of the opinion that we have it all heard on the 16th, and we will sort it all out to the best of my ability at that time. So we'll stand adjourned. Thank you.
Thank you, Judge.
You're going to draw the order?
I'll prepare an order, Judge. Thank you.